Jefferson County Court Law number 2 is back in session. Court is in session. And cause number M331560, case the style of state of Texas versus Ja'Cory Lee Grant. Mr. Grant, would you please raise your right hand? Mr. Grant, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Grant, you may put your hand down. How are you doing, Mr. Grant? You doing good?
Yes, sir.
I'm doing fine. Thanks for asking. Mr. Grant, you're here represented by your attorney, Attorney Brevin Jackson. Mr. Jackson, do you waive a record in Mr. Grant's case?
Yes, Your Honor.
Now, Mr. Grant, now state, I have before me a motion to forfeit. Mr. Grant, do you recognize this motion
Yes, sir.
to forfeit? And is this your signature on the line that is titled defendant? You have to speak up.
Yes, sir.
And now, Mr. Grant, before you sign this document, did your attorney, Attorney Jackson, go over this document with you?
Yes, sir.
And did you read and understand everything in this document?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? It is?
Yes, sir.
Mr. Grant, in this document, this weapon in this case is being forfeited to the Beaumont Police Department. And the court is going to grant this forfeiture to the Beaumont Police Department. The court is signing the order to forfeit this weapon. I gotta put it in there. And this weapon, clause number M331560, is hereby forfeited to the Beaumont Police Department. State, do you have an additional motion?
Your Honor, we have a motion for the dismissal of this particular case.
Okay. Now, let me, do you have the an inventory attached?
We don't, and because of the dismissal judge,
That's what it has to have with this inventory.
Discovery certification?
No.
an inventory of the
Hold on. Pursuant to Article Jefferson County Code Law number 2 is back in session and cause number M 331-560. State, do you have an additional motion?
We just have the motion for dismiss, Your Honor.
Okay, now, Mr. Grant, the state has filed a motion to dismiss in this case. And what is this? This document is currently locked for editing.
What'd you do?
Hold on, let me clear the log. Try it now.
Okay. Okay, there it is. And Mr. Grant, I'm signing this. Signing this motion or this order to dismiss. I just signed the order to dismiss, sending it to the clerk. You'll be able, your attorney will be able to give you a copy. Now, Mr. Grant, if this is the only thing holding you in jail, you should be getting out of jail today. So, do you need his prints? No, you don't need his prints on that. Just follow the bailiff and have a blessed day.
If he wants a copy of this dismissal, I can get it.
Okay, you can give,
Yeah.
his attorney could give it to him.
Hey, good luck.
This was who, Grant?
Yeah.
Yes. Who we have? Who we have next? Jefferson County Court, law number 2 is back in session. The court is in session in 2 cases. First case is cause number M333982. The second case is cause number M321908.
I don't know why.
Both cases are filed in the state of Texas versus Isaiah Kyrie Members.
Yes, sir.
How you doing, Mr. Members?
I'm doing good, and you yourself, Your Honor?
I'm doing fine. Mr. Members, would you please raise your right hand? Mr. Members, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Members, you're here in cause number M321908-2. You're represented by Attorney Samuel Millich Jr. Mr. Millich, how are you doing?
I'm doing well, Your Honor. How about yourself?
I'm doing fine. Thanks for asking. Mr. Millich, do you waive a record in Mr. Members' case?
I do, Your Honor.
Mr. Members, I have before me a document that's titled Motion to Revoke Unadjudicated Probation. In this motion, Mr. Members, it alleges that you, Isaiah Kyrie Members, was tried in County Court at Law number 2 of Jefferson County, Texas, on February 10 of 2021 for the offense of burglary of a vehicle. On that date, the court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for the offense of burglary of a vehicle. However, the court deferred a finding of guilt and placed you on unadjudicated probation for a period of 2 years. In this motion, Mr. Members, there are 7 allegations. State, are you abandoning allegations 1, 2, 3, 4, 5, and 7?
That's correct, Your Honor.
Mr.
Proceeding on allegations.
Mr. Members, the state is abandoning allegation 1, 2, 3, 4, 5, and 7. And that simply means that they will only be proceeding on one allegation. That allegation is allegation 6. And allegation 6 states that you, Isaiah Kyrie Members, have failed to submit to alcohol and drug screening on September 7th of 2022 in violation of condition 15 of your probation order. Is that true or not true?
True, Your Honor.
Now, are you pleading true to allegation number 6 freely and voluntarily?
Yes, Your Honor.
And are you pleading true because it is true?
Yes, Your Honor.
Mr. Members, I also have before me a document that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes, Your Honor.
On page 2 of this same document, there are a set of initials next to a box that's checked MTRP, which means motion to revoke probation, true to allegation 6. Are these your initials on this document?
Yes, Your Honor.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, Your Honor.
On the next document is titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, Your Honor.
The second box that's checked states that you're waiving your right to an appeal. Do you understand that?
Yes, Your Honor.
Now, Mr. Members, before you sign and initiate all of these documents that I've just mentioned to you, did your attorney, Mr. Millich, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Members, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1?
But we can show at this time.
Any objections? No objection. State's Exhibit number 1 will be admitted. Mr. Millich, you've advised and counseled Mr. Members, is there any evidence that he is currently mentally incompetent to stand trial?
There's no evidence of such.
And Mr. Members, your attorney, Mr. Millich, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, Your Honor.
Mr. Members, I will accept your plea of true to allegation number 6. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to revoke your unadjudicated probation and your unadjudicated probation is hereby revoked. State, do we have a plea bargain agreement?
Do your honor.
What is that agreement?
In exchange for a plea, true to the allegation, first of all, say what we asked the court to do, just one notice of the court's filing on the cause number. Also, the defendant's plea, if true, we'd ask you to take judicial notice of that plea. To find that allegation true, proceed to the sentencing, your honor, or punishment. At this time, states agreed, or condition of a plea of true. Also, a dismissal for the underlying case of reckless driving, which is, excuse me, make sure I got the page right. Time served for 20, I believe 26 days, your honor, is that correct?
It was 12.
12 days, excuse me, 12 days. For credit for 12 days, tax and retire, court costs, also as time served, judge. And like I said before, agreement for the, and also part of this plea agreement in exchange for this plea of true, the state pleads to dismiss cause number 333-982.
Okay. Mr. Members, the state is offering that you serve 12 days in the Jefferson County Jail. However, you do not have to serve any more time in jail on this case because you've already served 12 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court cost in this case is $67, but you will not be required to pay the court cost of $67 because the time that you spent in jail has already paid it off. Therefore, the court cost will be taxed and retired. And the state will be dismissing the companion case, cause number M333982. Mr. Members, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Members, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Members, if you do not have anything else holding you in jail, you should be getting out the day.
Yes, Your
All
Honor.
right. Now, Mr. Members, this will conclude your case. You're gonna stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Yes, Your Honor.
I need to have a specific question for Mr.
Yeah, but okay. Just have a seat in the jury box, and she'll call you back up
Yes, sir.
when she's ready.
Can I see Mr. Gonzalez?
Yeah.
You meet or mine?
I don't think you have to sign anything else,
Okay.
and you're free to go. All right. Jefferson County Court, Item number 2 is back in session. Court is in session and cause number M333876. Case style of State of Texas versus Hunter Gage Dryden. Mr. Dryden, is that your full name?
Yes, sir.
Mr. Dryden, would you please raise your right hand? Mr. Dryden, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Dryden, you may put your hand down. How are you doing, Mr. Dryden?
Doing all right. How are you, John?
I'm doing fine. Thanks for asking. Mr. Dryden, you are represented in this case by your attorney, Nathan Reynolds. Attorney Reynolds, how are you doing?
Doing well there, thanks.
That's good. Now, Mr. Reynolds, do you waive a record in Mr. Dryden's case?
So wait, here.
Mr. Dryden,
Yes, sir.
I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that on or about November 11 of 2022, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of evading arrest, detention. Mr. Dryden, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Dryden, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
I disagree with the plea agreement. I believe he signed, the guilty. I'm just going with.
Hold on, wait up, hold on a minute. Okay, my question, no, that's right, I see here, you entered a plea of guilty. Are you pleading guilty to this charge?
That's what I meant, what I was just going with.
Okay, just listen to my question. Did you sign, are these your initials on this document where it says guilty?
Yes, sir.
Now, are you pleading guilty because you are guilty?
Yes, sir.
And are you pleading, okay. Okay. Now, Mr. Dryden, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials, HD. Did you place your initials on this document?
Yes, sir.
On the line that's titled guilty?
Yes, sir.
That's checked guilty. On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
On the next page, the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The
Yes,
first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
And I also have before me a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the document that's titled
Yes, sir.
Defendant? Now, Mr. Dryden, before you signed and initialed these documents, did your attorney, Mr. Reynolds, go over these documents with you?
Yes, sir.
And did you understand everything that Mr. Reynolds went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Dryden, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, would you like to offer State's 1?
Yes, Your Honor.
There are no objections yet.
No objection. State's Exhibit Number 1 will be admitted. Mr. Reynolds, you've advised and counseled Mr. Dryden. Is there any evidence that he is currently mentally incompetent to stand trial?
None to my knowledge.
Mr. Dryden, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with his services?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Dryden, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor. Second for plead guilty, state to refuse. No contest, I apologize. No
Is
contest.
guilty?
It was guilty.
Yeah.
State for plead guilty, the state's agreement recommended 20 days in jail, the court calls. He's got 20 days jail credit. We ask to that this be time served, Your Honor, and we ask that the court possibly taxable time.
Okay. Mr. Dryden, the state is offering that you serve 20 days in Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail because you have already served 20 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court cost in this case is $327, but you will not be required to pay the $327 court cost because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Dryden, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Dryden, I will follow the plea bargaining agreement that you have entered into with the state. Mr. Dryden, do we need him?
I'm still working on the
Okay,
first one.
just have a seat in the jury box.
Yes, sir.
Okay,
Sorry.
good morning. Next case is John Wagner.
Are those defendants in the first one?
Yes. Jefferson County Court at Law number 2 is now in session. The court is in session and calls number M333616. The case is styled the state of Texas versus John Hugh Wagner. Mr. Wagner, would you please raise your right hand? Mr. Wagner, you can raise it like this here. Not, I said your right, not your, that's your left hand. Yeah, that's right. Thank you. Mr. Wagner, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Wagner, you may put your hand down. Mr. Wagner, your full name is John Hugh Wagner. How are you doing, Mr. Wagner? You doing all right? Mr. Wagner, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that on or about September 1st of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, search, transportation. Mr. Wagner, do you understand what you've been charged with? You don't understand what you've been charged with? Okay. Let's, you can put him back up. I'll give you another chance to talk to him. Okay. Okay, well, that's Wagner. Yeah, we're not gonna go forward on this. I'm gonna just send it back to her. Who's that? Kimmy Nash? Kimmy Nash?
Female Holmes.
Mr. Members? Hi, Mr. Members. Can I get your right thumbprint 3 times on this piece of paper? Just that blank space.
Jefferson County Court at Law number 2 is in session. Court is in session and calls number M333738. Case is filed with State of Texas versus Kimmy Briani Pete Nash. Is that your full name? Kimmy? Kimberly? Kimberly. Okay. Firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. You may put your hand down. How are you doing? I think, is your last name Pete Nash?
Yes, sir.
How you doing, Miss Pete Nash? You doing fine? That's good, Miss Pete. Oh, I'm doing fine. Thanks for asking. Miss Pete Nash, you're here represented by your attorney, Attorney Nathan Reynolds. Attorney Reynolds, do you waive a record in Miss Pete Nash case?
So wave, Jim.
Miss Pete Nash, I have before me in cause number M333738, a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that on or about December 9th of 2020, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you, Ms. Kimmy Briani Pete Nash, committed the Class B misdemeanor offense of driving while intoxicated. Ms. Nash, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Nash, how do you plead? Guilty, not guilty, or no contest? Now, you're pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty? Ms. Nash, I have before me a document that is titled misdemeanor plea admonishment, also labeled as State's Exhibit Number 1. You recognize this document?
Yes.
On page 2 of this same document, Ms. Nash, there's a set of initials, R as a KN. On the line next to a box is check guilty.
Yes.
Did you place your initials on this document? I also have before me on this document a signature on the line that is titled defendant. Is this your signature? On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
Second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes.
Now, Ms. Nash, I also have a document before me that is titled Discovery Certification. You recognize this document? And is this your signature on this document?
Yes, sir.
Now, Ms. Nash, I think on the previous document, you said it was your signature was KN. Are those your initials or that's your signature?
I only use Nash.
Huh?
I have 2 last names wrong in my head.
I know, but I'm just saying the signature on this document is different from the signature on this document. This document where it says signature, you have your initials.
Oh, okay.
Okay, because I need you to change it to your signature on that page.
That's my fault.
Okay, Mr. Alpart, you gotta sign this document. And also Ms. Nash, on trial court certification, defendant's right of appeal, this is your signature, right? And you understand that this is a plea bargain case, you have no right of appeal. You understand? And you also understand that you are waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that? Now, before you sign any initial these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, now, Ms. Nash, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, would you like to offer State's Exhibit Number 1 into evidence?
Yes, sir.
Any
No objection, Judge.
No objection. State's Exhibit Number 1 will be admitted into evidence. Mr. Reynolds, you've advised in Councilman Nash. Is there any evidence that she is currently mentally incompetent to stand trial?
Not to my knowledge.
Ms. Nash, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
Ms. Nash, I will find that you are, well, first of all, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
The change of plea, no contest, in that case, they were guilty. In this case, the state agreed to recommend 30 days in jail. Court costs with credit for 30 days in jail. This would be a time served plea, Your Honor, and we'd ask the tax attorney.
Ms. Nash, the state is offering that you serve 30 days in Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail on this case because you have already served 30 days in Jefferson County Jail. Therefore, you will be given credit for the time that you have already served. The court cost in this case is $442, but you will not be required to pay the $442 court cost because the time that you spent in jail has already paid it off. Therefore, the court cost will be taxed and retired. Do you understand that? Now, Ms. Nash, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Ms. Nash, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Nash, just have a seat in the jury box.
Judge,
You are.
who was the one that got sent back? Was that, Granger? What was his name?
Tyrone Williams. Jefferson County Court Law number 2 is back in session. The court is in session in 2 cases. First case is cause number M333608. Second case cause number is M333604. Both cases are styled the state of Texas versus Tyrone Chad Williams Jr. Mr. Williams, would you please raise your right hand? Ms. Williams, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Williams, you may put your hand down. How are you doing, Mr. Williams? You doing all right? Now, Mr. Williams, you're here represented by your attorney Nathan Reynolds. Attorney Reynolds, do you waive a record in Mr. Williams' case?
So wait, Jim.
Mr. Williams, in cause number 333608, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that on or about May 30th of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of a resisting arrest, search, transportation. Excuse me. Mr. Williams, do you understand what you've been charged with? And to this charge, Mr. Williams, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading guilty freely and voluntarily? Are you pleading guilty freely and voluntarily? Is somebody forcing you to plead guilty? So you're doing it of your own free will? Okay. Now, Mr. Williams, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? Show it to him. You might be able to just leave it there.
This is where we talked about the range of punishment. The next page is where you said.
You recognize that document? Okay. On page 2 of the same document, there's a signature above the line that is titled guilty. No, these are, initials above the line that is titled guilty. Did you place your initials on this document?
As far as I can see, sir.
Okay, get us to him and you can keep it down there.
Okay.
The initials on the line, are those your initials?
Yes, sir.
Okay, go to the next page. At the, on the next page at the top, above the line that is titled defendant, there's a signature. Is that your signature? You have to speak up. Okay, now go to the next page. On the next page, that, well, actually, the next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize that document?
Yes, sir.
Is that your signature at the bottom of the document above the line that's titled defendant?
Yes, sir.
At the top of that document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that? Okay, you can give him this here. Now, the next document that your attorney is showing you is titled Discovery Certification. Do you recognize that document?
Yes, sir.
And is that your signature on the line that is titled defendant?
Yes, sir. Your Honor.
Now, all of these documents that was just showed to you by your attorney, did your attorney go over these documents with you?
Yes, sir. He did.
And did you read and understand everything that he went over?
Yes, sir. I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir. They are.
Mr. Williams, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1 into evidence?
Yes, Your Honor.
There are no objections, Judge?
No objection. State's Exhibit number 1 will be admitted into evidence. Mr. Reynolds, you have advised and counseled Mr. Williams. You gotta sign that. Mr. Reynolds, you've advised and counseled Mr. Williams. Is there any evidence that he is currently mentally incompetent to stand trial?
None to my knowledge.
Mr. Williams, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with his representation? Are you satisfied with your attorney's representation of you?
Yes, sir. Yes, sir.
Has he provided full, effective, and competent legal representation? Mr. Williams, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
We stand for plea guilty in this case. State degree to recommend 26 days in county jail and court costs with 26 days credit of the time served plea, and we'd ask pass the trial of the court cost. Also, in exchange for this plea of guilty in this case, judge the state's agreed to dismiss cause number M333604.
Mr. Members, the state is, excuse me, Mr. Williams, the state is offering that you serve 26 days in the Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail on this case because you've already served 26 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. And the court cost in this case is $327, but you will not be required to pay the $327 court cost because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Williams, do you understand the state's offer?
Yes, sir, Your Honor.
And do you think that the state's offer in your case is fair and just?
Yes, sir, Your Honor.
And do you accept the state's offer?
I accept
Mi-
the state's offer.
Okay, Mr. Williams, I'll follow the plea bargain agreement that you have entered into with the state. And Mr. Williams, this will conclude your case. Please have a seat in the jury box. And this will conclude the calling.
This didn't do
They've been,
it. Shun Simon.
those next two cases are being dismissed. I'm just asking.
Simon, and then-
That one covers it, or LeBlanc covers it.
it will be starting our jury trial in a few minutes once we finish with Mr. Williams. Bill, if you can go get the jury. Everyone, please stand. Everyone may please be seated. Let the record reflect that the cause number M329248 is back in session. Case is styled the state of Texas versus Herbert Glenn Harrison Jr. Let the record also reflect that Herbert Glenn Harrison Jr. is present in court with his attorney, Attorney John West. Let the record also reflect that Assistant District Attorney Colby Hoffmeyer is present representing the state of Texas. And let the record reflect that the jury is now present in the courtroom. State, are you ready to proceed?
Thanks, Rodney.
Defense, are you ready to proceed? At this time, ladies and gentlemen of the jury, I will read to you the charge of the court containing the law applicable to this case. The defendant, Herbert Glenn Harrison Jr., stands charged with the offense of resisting arrest, search, transportation, alleged to have been committed in Jefferson County, Texas, on or about the 14th day of February, 2021. To this charge, the defendant has entered a plea of not guilty. A person commits the offense if he intentionally prevents or obstructs a person he knows is a peace officer from effecting an arrest, search, or transportation of the actor by using force against the peace officer. It is no defense that the arrest was unlawful. So that you may better understand the nature of the offense with which the defendant is charged, I now define certain terms and words. A person acts intentionally or with intent with respect to the nature of his conduct when it is the conscious objective or desire to cause the result. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Herbert Glenn Harrison Jr., did then and there in Jefferson County, Texas, on or about the 14th day of February, did then and there intentionally obstruct or prevent Roderick Williams from effecting the transportation of the defendant by using force against Roderick Williams, a peace officer, and the defendant knew that Roderick Williams was a peace officer, you will find the defendant guilty. Unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that the person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a person or defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty. And it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution's proof guilt beyond all reasonable doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The questions will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence, nor legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page is the verdict page. If you notice, there are two sections, one at the top and one at the bottom. Now, the one at the top states, we, the jury, find the defendant not guilty of resisting arrest, search, transportation. If that is your verdict, then your foreperson will sign on the top line. The bottom verdict states, we, the jury, find the defendant guilty as charged in the information of resisting arrest, search, transportation. If that is the jury verdict, then your foreperson will sign on the bottom line. Does everyone understand? State, are you ready? And defense, are you ready?
Ready, Your Honor.
Mr. Hoffbauer, you have a right to open and close in closing argument. Would you like?
What we're gonna do is waive our right to open, our right to close in this case.
Okay, so at this time, each side will be given 20 minutes, and I will be keeping time. Mr. West, the panel or the jury is yours.
Morning, members of the jury. Yes, it's still morning. We have a little more time left. There's an old saying, adage in our profession, that if the facts are on your side, you argue the facts. If the law's on your side, you argue the law. There's more to it. It's funnier, but that first part really makes a lot of sense here. Today's one of those weird cases that I'm not going to argue the facts. I think the facts are clear. I don't think there's a dispute on what the facts are. We're going to be mainly focused today on the law. And what's the law? The law is the judge's read to you, the chart. You're going to get that in a moment. All right. Number 3 in here is what you have to make your decision based on. Right. This is the charging part of this document. It says, therefore, if you believe from the evidence beyond a reasonable doubt that the defendant Herbert Glenn Harrison Jr. did in Jefferson County, Texas, on or about the 14th day of February 2021, did then and there intentionally obstruct and prevent Roger Williams from affecting the transportation of the defendant by using force against Roger Williams, a peace officer, and the defendant knew that Roger Williams was a peace officer, you will find the defendant guilty. So let's talk about this in different elements. Mr. Hoffbauer is going to break them apart. I'm sure he will, because that's what we are all taught as prosecutors to do, to go over each one individually and make sure you got each one of them. You have a checklist. We always have checklists. First part, defendant Herbert Glenn Harrison, is that him? Yeah, I think there's no dispute about that. We saw him on video. That's him. Okay. In Jefferson County, Texas, we saw where it was. There's no dispute about that. The facts are the facts. Right. On about the 14th day of February 2021. I think that's the day. That's what the officer says today. There's no reason to dispute that. That's about right. Did then there intentionally obstruct and prevent Roger Williams? Something you have to determine in a second. But here's where we get to really the meat of this. From affecting the transportation of the defendant by using force against Roger Williams, a peace officer. And we're going to come back to that and talk about that quite a bit. And the defendant knew that Roger Williams was a peace officer. I don't think it's disputed that he was a peace officer, like a police officer, a police cruiser, whatever you want to call it. That's not a problem. What did Mr. Harrison do out there? He didn't comply. We saw that. You saw the video. It's kind of a rough video. He was pretty mouthy. He was being a jerk. He was being very, very belligerent, very hostile, very aggressive, very mean. Whatever you want to call it, however you want to describe it. Not a nice situation. Okay. We also know that he was very intoxicated. We heard about that too. So maybe he's a mean guy. Maybe he's a nice guy that just got intoxicated. We don't know, but nevertheless, he was bad out there. Okay. Even the officer stated that he was, and I wrote this down directly when the officer said that he was not in his right mind. What he said. Now, the reason I bring that up is a couple of things. Is first thing is, Mr. Harrison is not on trial today for intoxication for public intoxication. That's not what this trial is. That's got a different charge, different court, different situation. Okay, so you can't find him guilty of this offense because you think he's intoxicated. We all can see that. It's clear. And he's not on trial today for being a jerk, being rude, being belligerent, being mean, whatever you want to call it. That's not a crime. You know, sometimes we wish that would be a crime when we're out in public or whatever, but it's not a crime to be that way. But I want to bring up the fact that the officer said he's not in his right mind, because part of it says that you have to hold that he's intentional. Okay, that's in there. That's part of the word right there. Okay, that he intentionally did this, and the judge defined intentionally. I'm going to read right from the charge here. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to cause a result. Okay. And again, I'm reading all these things over again to you, what the judge did, because I said earlier, this is the case, not about the facts or what the facts are, it's how those facts apply to this. Right? So let's talk about what Mr. Harrison did that we're here today to talk about. He didn't put his foot in the door. He tried to shut the door and try to get him in the front. And he kept his foot out, or I don't know which foot it was, one of the foot, right? And some parties pushing back on the door, not letting him shut the door, all right? And that's why he's here. That is not. That says right there, okay? It says from affecting the transportation of the defendant by using force against Roger Holmes. Okay, that's what you have to determine is the force that he used out there that night. Is that force against the officer? Okay? Like I said, the facts aren't in dispute. Saw the video. Now, Mr. Hopper is going to get up in a moment, and like I said, I said before, we joke saying try hundreds. We have over hundreds each other of each other, but legitimately probably dozens. Okay, over the last 17 years, we've done a lot of trials against each other. And I know he's going to point out, because I know if I was this, I would point out this too. Okay, he's going to say that about him pushing on the door, pushed against the officer, and that's what the force was. By him not complying, not letting him do that, was using force against what the officer is trying to do. Okay, but that's not what the legislature put in the law. They could have easily put that in this part here when it got to that point. Intentionally obstruct and prevent Roger Williams from affecting the transportation of the defendant by using force, and the defendant knew that Roger Williams was a police officer. They could have left that part out against the officer, which is in the first paragraph here. But they specifically put in there, right here, I'm sorry, second paragraph, using force against the peace officer. That's what the law says. To violate this crime, this penal code section, you gotta use force against the officer. Another thing Mr. Hoffmeyer is going to point out in a moment to you is that, well, if you had to use force against the officer, that would be another charge of felony. Assault on a public servant. And he's right. We see those cases quite often. But the problem with that is that there needs to be other elements to get to that level. There has to be bodily injury. Okay, you have to injure the officer to get to that felony level. That's not the felony. We don't want officers being injured. Okay, but what about this code? This code and this law, this statute talks about if you use force against maybe pushing or something like that. And it doesn't only injure the officer, but it's still using force outward to them. Okay? That's what this is talking about. Okay? You know, you go to put cuffs on you, you push the officer away or something like that. You know, they try to put you in the car and you pull back and you push them off, shove them, something like that. That's what my client did. That's what my sheriff did. He got in the car, we saw that. He also talked about he was able to cuff him and place him under arrest, no problem. Was able to search him, saw him trying to back up in the car and all that he did. It's just when he went into the car, he again was pretty intoxicated, didn't want to go anywhere. And so he kept putting his foot out the door and pushed on the door. That is not what this law was meant to prevent. He was not compliant. He was rude. He was intoxicated. He was mean. He was belligerent. But he did not use force against the officer. I asked the officer, did he kick you? No. Did he hit you? No. Did he touch you? No. Case closed. That's pretty much it right there. You have to have that element. We talked about in Word Hour that it's their burden to make each and every one of these elements beyond a reasonable doubt. Okay. And we talked about it, so it's like, what if he just won? Remember, Mr. Hopper was like, that's not guilty, even admitted that. And that's what happened here. You know, and again, I'm gonna talk highly of Mr. Hopper. He's a great prosecutor. I mean, when he was an intern, he had a good teacher. I'll be a good joke about that. He can't make up evidence. He can't make the facts fit the law. He can only present you the facts, okay? He did a great job of it. He went over and beyond. He brought you pictures of the scene and all that stuff to really nail down every one of his elements that he could. But he did not have this one element. He did not have that one word against the officer. And that's what you have to decide. Like I said, this is not a situation of, did he do what they say he did? Yeah, he did. All the stuff on the video, there's no dispute about that. Is this a situation where he used force against an officer? And it's clearly no. They haven't shown you that. Your verdict must be not guilty.
Mr. Hopper?
Thank you. I'm on, if I can use the monitor, I think maybe Mr. Gura and the.
Yeah. Mr. Did you get Mr. Gura?
Mr. Court, I'm gonna wait till Mr. Porter gets back.
Yeah, she should be in a few minutes.
I think it's
Okay,
It's
if
there,
you
but I'll
want to
wait
go
for Mr.
forward,
Porter. I don't want to mean, okay, whatever the court wants. It's
we
with,
didn't put the. Yeah. That's fine. You may proceed.
all right, good, well, good morning. I thank y'all again for all your patience, and I know it's taking longer, but I appreciate you, and it's important, okay? Now, I'm gonna go through a lot of things, obviously, we agree on a lot of things that y'all heard from the defense counsel. There's a lot of these elements that we talked about that there aren't in dispute, okay? Now, you hear the elements, the defendant, Herbert Glenn Harrison Jr., on or about February 14, 2021, in Jefferson County, Texas. All three of those, the defense is not disputing, they agreed this happened. They aren't disputing it. So check off those three. Did intentionally, we're gonna talk about that in a minute, okay? Prevent and or obstruct Roger Williams, who the defendant knew to be a peace officer, from affecting the transport of the defendant by using force against Roger Williams. Now, in regards to the defendant knew to be a peace officer, they're not in dispute. He was wearing his uniform. Officer said, and y'all watched the video. You saw him say officer this, officer that over and over again. He knows it's an officer. That's not in dispute. Check that box. Now, prevent and or obstruct. All right, let's go back over what we talked about there to stop something or keep it from occurring. Common sense definition. Now, obstruct is to prevent or to make progress or activity difficult. Right? Now, all of this is arrest, search, or transport. You understand all that. We're just talking about transport. That's the only thing. And that is transporting an individual by law enforcement personnel. That's exactly what happened here. There's not a dispute with defense counsel in regards to that either. Now, use of force. All right, let's talk about that. Texas courts have determined any amount of physical force is sufficient for the person resisting arrest or transport charges. Okay. Now, I want to make clear that so the only element in dispute here, right, through what counsel said, is intentional, okay, and whether or not it was the use of force against the officer. Everything else they've agreed to, you don't even have to worry about, all right? Now, so what we're talking about is use of force, so that's in dispute. So they don't even disagree, so I'm not gonna go over, I'm gonna go through the elements like I'm supposed to. Counsel knows that, all right? I'm gonna make sure you understand and remind you of what you saw, but you saw that. Now, look, everything, I want to make sure I say this before I forget, everything that's entered into evidence, all right, you can ask for and look at. If you need to watch it again, please watch it again. Take as much time as you need to do that, all right? You've got the video, we watched the video of Officer Roger Williams, okay? I also entered the evidence of Officer Eric, I'll say that. I entered it, but I didn't play it for the purposes of, it's the same thing, it's just from a different view, but it's in evidence. So that if you want to review it, please go and review it. It's in evidence for that purpose. Now, I did it for the purposes of efficiency to move along because you saw everything you needed to see in the video. The testimony is fine, but the video is the video. They don't dispute it. They don't dispute he was intoxicated. They don't dispute that he was unruly, all right, or that he was difficult with the officer. Okay, so what their dispute is technicality. Okay, he wants it to be a technicality of whether the force was applied to the door versus the officer, or if how much force. It wasn't enough to be an assault on an officer. I mean, it didn't cause bodily injury, so it's not that, right? So it wants to be on a technicality. Sometimes he acted unruly and did not comply enough, but not enough for it to be a charge. And where does it fall? We do have a charge for this particular kind of act. And it's the one I'm bringing to you here today. It's clear on the video. There's nothing there's no trickery. There's nothing that you have an equation you have to do with this. You just have to watch the video and read the law. The law is clear, right? Use of force. Now, what I want to make sure you understand is that you had two witnesses, all right? They're the only officers out there and the other person. That was it, okay? This is all about somebody who was, you saw that. They observed somebody was acting. They got a call from the clerk, okay? The video, once again, the video of body camera, and look at the in-cars if you want to, please. The in-car of the back of the defendant being transported. Also of the action of the defendant while the body cam is facing in. It shows you, and we showed some of that, the way he moved his body when they stopped him, or they finally got the legs in, okay? Despite the use of force of the defendant against the door, against the officers. It wasn't just the door, it was also against the officer. It wouldn't let it put his leg in, he kept sticking it out. At one point, you see his leg, you see the skin of his leg. His officer had it over his head because he was sticking it out to make sure the door couldn't close. He's using force against the officer. Then he kick him in the face. Is that what we're going to require for that? No, that would be an assault on a peace officer. All it is use of force. And what did the court say? Any use of force. Now, is he resisting arrest or anything? That's not what we're saying. Transported. He's not allowing them to shut the door. And if they can't do it, mean shut the door, they can't move the car an inch. They can't move it anything. We cannot transport somebody unsafely. Now, would we want our officers to do that? Really? We want to be like, well, they're not going to apply. Oh, well, just leave his leg out. I mean, if he wants to keep it, he'll pull it in. Do we do that? Do we expect government officials to do that? Really? But if they won't comply, if they won't do that, we have to make sure it's safe before we transport. Okay? And they don't decide, the defendant, whether or not he's drunk or not. First of all, let's get this out of the way. Voluntary intoxication is not the defense of anything. All right. You can't get so drunk that you can't follow the law, and this is how you get out. Now, y'all know that. I don't think voluntary intoxication is not a defense. I was so drunk I can't remember what I did. That doesn't apply. Right? It just doesn't. Now, was in regards to whether or not it was intentional, I think you know, and you can watch what was intentional and what was not. You know what someone's doing on purpose and what they're not doing. It wasn't like he was out of it. He was out of his mind because he was intoxicated. But he knew what he was doing. He knew he was keeping them from transporting. Why would he be applying force? I'm not saying he's trying to hurt him, but he was making sure he didn't go nowhere because he knew where he was going. They told him, but he wasn't listening to what he wanted to ask and ask and ask. What am I charged with? They said it. If he didn't listen. Now, what do we expect the officers to do with that? Think about that. They're trained to deal with this, but this guy wouldn't do that when he got the door closed. What did he do? He checked his head out. But he knows they're not going to slam his head in the door, right? So do we expect them to do that? Do we expect them to get in the car and start driving to jail with his head hanging out? I think that's unreasonable. It's not going to happen. So if you would prevent it, any use of force, which they testified to, And we'll go over that, okay? Now, everything you need to know is on the video. The testimony is important for sure, for credibility of those witnesses. But both those officers said exactly what was on that. There wasn't anything that didn't match what you saw on there. And if you need to watch officers, I'll say that's why I put it in. So that if you need to review, please review. But it is the same, it's the same action because they're working in tandem on an unruly individual who will not comply and won't listen. Now, I'm not like counsel said, just he didn't hit him, fine, but are we judging that by like he didn't hit him? It's just transport. We're not saying assault. Okay, we're just saying resisting the transport. Now, what did y'all see? We saw a guy who wouldn't have let him shut the door. Does he have to say, I don't want to go to jail for resisting transport for it to be that? Or can you be reasonable with your common sense? Remember, nobody left that. It's just reasonable. He didn't want to go. He wasn't going to be taken. And in fact, the whole time, he was threatening to sue him for like it was a bad charge. Now, has nothing, and those officers handled it. They didn't get angry, they didn't start hounding on him, they didn't start to do those things, but they still have to do their job, right? What would we want them to do? Well, we said, this guy's so unruly, here's your keys, please get back in your car. Now, is that reasonable? Think about that. Now, would we do that? Would we want these officers to do that? Knowing that he's intoxicated and he's got a vehicle that he was driving right there. He was leaving. So, and what do we expect him to do? They're gonna put him on the road? Because he won't get in the car? This is not reasonable. Okay, now, you heard the testimony. It's not in dispute. It happened at this time. It's Jefferson County. It's a speedy stop on MOK and Washington Boulevard, Beaumont, Texas, Jefferson County, Texas. Now, I'm going to do what counsel says that I do, but this is important because every case has to be done this way. You understand? We don't cut corners. We want to be efficient, but that's not what we do. All right. That defendant deserves every right of every element to be proven beyond a reasonable doubt. So I'm not going to skip any steps either. All right. Because that's important, but we do it every time in every case. Okay. So let's do it. What Officer Roger Williams testified, he was dispatched to speedy stop on Washington and MOK. He observed a black male matching the description from dispatch, and it was sitting inside a white Camry, exactly the car that he was told on dispatch to go. In our Roger Williams, he asked his subject to exit the vehicle and walk towards his patrol vehicle. He was unsteady on his feet. His speech was slurred, strong alcoholic odor coming from his body. Counsel not arguing that he was highly intoxicated. He said very intoxicated. Agreed, very intoxicated. Now, they were detaining the suspect. You heard him say, you're being detained. Yes, he's not jumping to conclusions. He's not deciding immediately, look, I'm going to put him in arrest for DWI or anything like that. He's just finding out what is going on. At that point, he does the search. He's being detained. But when he's placing him in the vehicle of detention, he feels like, and he smells the odor more, and he's also got a guy who he's answered the question. And he won't listen. He keeps asking the question. He asked 25 times if he asked it once. All right. And he kept asking both of the officers over and over again. And then when he didn't get the right answer, he just asked it again. Okay. I don't know if he didn't hear it, or I don't know if he cared to hear it, or if he would just, he didn't want to get the answer that he wanted. It doesn't matter. Okay. He detained him. He did the search. Then he places under arrest. He would not put his leg inside the vehicle. Now I get that. No, I get that. And counsel, he's doing good. He wants it on technicality. What did he not do? He didn't fight him. It wasn't a big crazy episode. He just put his leg inside the vehicle. Now we asked our officers to go out there. We talked about this before. We asked them to go out there at 2:30 at night after the clubs are closed. They don't know all these, but they're the ones who call when people are unruly or people look like they're a danger to themselves or others. The clerk at the gas station said, we got a guy out here. Look, he's acting, he is bothering customers. We need somebody to deal with. Well, who gets called? The cops do, right? So they're trained to do it. So they go out there and do it. And then when they're trying to transport it in regards to this, he told him public intoxication. And he told you the reason why, didn't he? He told you why. He said, because I can't put him back in that car. He's intoxicated. I can't let him drive home. I can't put him back on our roads in Jefferson County, Texas. Every one of you and all of us drive, right? Okay, it ain't just his road, it's all our road, right? The officer's got to do what the best he can do. He's placing him in under arrest for public intoxication. Now, they're not even arguing that. Y'all saw the video. You don't need to be an expert in that. He wouldn't put his leg in so they could close the door. Then we want to talk about that. He tried multiple times to get him to put his leg inside the car, not by asking him. They tried to put it in there, and then he wouldn't. And when he tried to close the door, he stuck it out again, and he did use force against the officer through the door by pushing it. Now, if counsel wants to make little of that or use that, the problem with that is that's the first part of his action. I will argue to you that's force against the door, against the officer. To what? To prevent or obstruct him to be transported. What's the logical conclusion if the door is shut? Can they continue and transport him? Yes. Why? He said, safe now. Just by not letting him shut the door, they can't go anywhere. They told you they're not going to drive down there with 3 doors shut out of 4. Would you want to do that? Would we expect them to do it? No, we wouldn't do that. But that's the first part. All right. He wants you to just go on just that part. Talk to what the officers tell you and what they do. They were struggling with him. Both of them were forced against him. He stiffened up. He would not straighten up. And when they finally got him in, forcing him in from one side, and were pulling him from the back, what did he do? He used the door that was closed and to push against and stiffen up and put his head out the other door. Now, officer said, he testified to you, he had him up, like he could not get him up, and it was like dead weight, holding him dead weight. He wouldn't straighten up, and he wouldn't allow him to shut the door on the other side. That's using force too. That's where he forgot. I didn't talk about any of that. That's using force. That any one of those is sufficient for our charge. You understand what I'm saying? It's not just the first part of sticking your leg out. This is not just a defiance of somehow a code defiance of I will not follow, a conscious effort. I will not follow your direction. Right? This is not that. This is somebody who's pushing against officers who are out there trying to protect the community, and he's pushing against that, and he's pushing against both of them. Officer Salcido said that too. Okay, she said, yeah, he used force against both of them. And I even asked her, you could have had a charge of resisting against you as well of transport. Of course, that's what we're trying to do. Now, multiple times, and y'all saw this, it wasn't once, it wasn't 5 minutes. They were out there 20 minutes trying to get this guy to comply. So much so that what do they tell you about that? They had to go to the last resort, the wrap. Now, y'all saw what the wrap was. All right, it's not something like you use. It's a last resort because this guy would not comply so he could be transported. And he used his body force, he used his length, and he used the ability against those officers to close the doors of the car. Okay, that's what it is. There's not disputed these facts. It was intentional because you knew he was doing it. What you saw that, and this officer was it intentional? I said specifically. Was it intentional what he was doing, using force against you? Yes, it was intentional. Okay. He was telling me the thing, he was telling me why. I mean, he was telling me, I'm not, are y'all gonna, he threatened them with being fired, being sued. He threatened both of them personally with face saying, that's your job, you're gone, you're out of here. You're out of here, right? Well, what did that officer? They're like, we're gonna be fired over it. Okay. They still complied, they still acted like professionals, and they still did their job. Could they get them in there with 2 officers? No. And they called a wrap. And they wrapped him up, and they had to put him in that way. Now, did that ever stop? Anything stop? Finally, they could transport him. All right. Now, it's important for you to understand that, like we said, I agree with Count. He wants you to be that it was forcing us off of the door, not the other. That's forgetting all the other stuff that we all saw that was forced against both the officers, but specifically Roger Williams from transporting. It's not of arrest. It's not anything of transporting. You're using force in any way so they can't close the door. That satisfies the element. Now look, and I know we're belaboring the point. I want to make sure you understand. We're not belaboring the point for a reason. And counsel said, I'm going to go through the list. Like I said, I have to, because if it was you, you would want every one of those done. Why? Because it's important that every one of those. Oh, we don't skip anything. Why? Because it's liberty. This is important. All right. This is a criminal case. So no, we're not gonna skip steps. No, we're not gonna, hey, I'm not gonna gloss over that. Every one of those elements that, is on that video for you to see and through your testimony. You use your common sense. You have it. You didn't check it in. And I want you to make sure you understand the most important thing about this, all right? This is not personal in any way at all. I don't know Mr. Harrison from Adam. I don't know, okay? It's not personal in any way. So look, if you watch the evidence and you don't find each and every one of those elements beyond a reasonable doubt, what do? You send them home, because that's what we have to prove. Now, there's the other side of that. If you do find each and every one of those elements beyond a reasonable doubt, it's not personal. You find them guilty. You, as the jury, you get to decide what the facts are. The facts are undisputed. Y'all saw it. Watch it again if you need to. I don't think you need to. You get the law and the charge. Apply that to the charge and follow the law, right? If you don't find it, you find them not guilty. I think there are plenty of evidence to prove each and every one of those elements. To find this individual guilty. Thank you very much.
Ladies and gentlemen of the jury, at this time, all the evidence is in, and we're going to ask that you follow the bailiff to the courtroom. He will also have the charge for you to read while you're in the courtroom. Everyone, please stand. Court will now be in recess. You'll get a verdict.